What's up, everybody? Welcome back into another episode of The Lawyer You Know. I feel like it's been a while since we've been live together. I can't wait to answer your questions about this Karen Read civil case. It's been a long time since I've been this excited to break down a hearing and talk to you guys about a case. This is right in my wheelhouse. This is what I love to talk about. This is what I'm doing day in and day out. And there is so much to discuss from this hearing. Already, this case is unusual, not like most cases, but there are so many things in this case that are very standard and exactly how most cases seem to go. And we also have a lot that we can compare and contrast to what these lawyers are already arguing about and what we think is going to happen with the procedure of this case. Where is it going to go? How long is it going to take? We are going to get into that and so much more tonight. Thanks for being here with me. Thanks for coming to hang out. Hit that like button. Let's get to it. All right. So many people are saying I'm so confused about how this is working. How long does this take? People are used to the lightning speed and people pounding the table about a criminal defendant's right to a fair trial, right to a speedy trial. Let's move this along. Some cases still last forever, but in civil cases, it often feels slower than it needs to be. And we'll talk about why that is. We'll talk about a lot of what happened in this hearing and what the judge is actually saying. At the end, when we kind of hear the judge talk about how this case goes and some advice that he has for all the parties, that sounds a lot like a mediator in most of our mediations. And I'll explain why he's doing that and what effect that may have, if any, on the lawyers. So one of the important parts is in the very beginning of the case, 1 million lawyers represent Karen Read. It's like, okay, 2 lawyers on behalf of the plaintiff, and then this guy, this gal, that gal, all representing Karen Read in this courtroom. So many lawyers that they're filling up the counsel table, they're filling up the first bench, they're filling up the jury box. Everybody there seems to represent Karen Read. There's some C.F. McCarthy's lawyers. There's some Waterfall lawyers who are the other defendants here. Let's not forget about them. They have some arguments to make as well. But so many lawyers representing Karen Read, which is going to be interesting. And it puts the judge kind of on notice, right? We said all along, Alan Jackson was very pessimistic about cameras being in this courtroom. And I said, I feel like it comes down to the media requesting it. Maybe that's why Alan Jackson, who's very purposeful with all of his media interviews and what he's saying and what he's doing, maybe he's saying, like, I don't know if there's going to be courtroom or cameras in the courtroom, to put that pressure, put the push behind the media asking for it, and it eventually getting granted. And now we have cameras in the courtroom, and I can't tell you how many times the judge mentioned that today. And that is already a factor in what is happening in this courtroom. It's already making a difference to the lawyers and to the judge. So we're going to be breaking this down. Make sure you guys are subscribed as well. A bunch of people were saying like they signed in and they weren't subscribed. They didn't get the notification. So make sure you guys are all subscribed. Joanne said, Peter, glad to have you back. Watch the whole thing today. So many questions. Well, Joanne, I know you know this. That's why we're here. Cheryl, will Karen Read's defense be allowed to introduce the fact that she was found not guilty in the criminal trial? If so, how can she be held accountable for his death in this trial? So no, they won't be able to announce that, number one. Number two, different jurisdictions, different burdens of proof, criminal versus civil. It is a totally different set of circumstances. If it was flipped, it would be res judicata, is what we say, or something that's already been decided in the judicial system. If she was guilty in the criminal side because they have a higher burden of proof, the civil lawyers would have been able to say it's already been determined that she is at fault for John O'Keefe's death. That didn't happen, and it doesn't work in the reverse. All right. I skipped the beginning part, just how everybody says we're trying to get discovery from each other. The judge is like, we need to push for a trial date. We will talk more about that, but we're going to jump in with the bombshell announcement. And I'm putting it in quotes, but it really is a bombshell announcement and a surprise from the defense team. And I'll tell you why.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Read's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point.
So let's first mention what he said. I think he may have said affirmative defenses at some point, but now he says affirmative claims, and mixing that language is important, right? Because affirmative defenses have to stem from the complaint and will always be in this civil case. Affirmative claims or new claims that you have may or may not be connected and in this same case. They have to be inextricably intertwined and no reason to be removed anywhere else, which we'll talk about if that's what happens here. But you got to be very specific in your language about what you're calling for. And the fact that he is announcing this in open court, we're going to find out later for the first time, is what's a little unusual about this case.
Including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Read's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question.
So they plan to bring civil rights violations, could be 1983 actions, could be, I don't know, something else. We'll talk about that, against Proctor, Buchanan, and Tully, I think he said. And then, of course, the Alberts, the McCabe's, etc. They're going to be bringing civil conspiracy claims there. None of us are surprised that they're going to bring those claims. Here's the surprise to me. Number one, that they're announcing it in open court without telling plaintiff's counsel. And we'll see what the judge thinks about that. The second surprise is that not only are they bringing those claims, you haven't heard anybody talk about the fact that they are going to tie those claims together with this civil defense. And we'll talk about why. That's the surprise to me, is that they're going to try to make this all one case. And as we listen to the hearing, we'll talk about the arguments for and against that. That is the surprise to me. And why would that be good for Karen Read? Well, number one, if these defense lawyers who are being paid by her insurance company are going to help in prosecuting those claims, it could save her money. If she's paying Alan Jackson or some of these private counsel out of pocket, that's going to be expensive, obviously, and that could be an issue. But if she is going to have experts and lawyers potentially working on this civil defense that will also work on prosecuting claims, because we've been brought in on cases to prosecute claims, but we're not doing any of the defense work, right? And the defense lawyers are not doing any of the work that we're doing prosecuting claims, even though it's all merged into one. So sometimes you separate what lawyer's doing what, but if they're all working together, it can save her a ton of money and time to merge these together.
Those claims will be in the nature of civil conspiracy, violation of Karen Read's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Read in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would...
10 additional parties coming in. And I'll tell you, if I was plaintiff's counsel in this case, already I wouldn't take it, right? Just get that out of the way. Well, I'm still going to try to explain what they're thinking and what they would do. I would never take this case. It feels like a dead bang loser. But if I'm sitting over there and I'm hearing this for the first time, I'm hanging my head. Like, you've got to be kidding me. I do not want to deal with this. I just killed a bug with my hand, so now it's all over my hand. I do not want to deal with this. I want no part of this. It's going to muck up my claim. It's going to muddy my claim. I've got a wrongful death case and some intentional and negligent infliction of emotional distress claims. I want to prosecute those. This would be an absolute nightmare. You better believe they're going to do everything they can to fight to keep these cases separate. But what the defense is trying to do is say these are so inextricably intertwined. These are the same exact facts. We're going to do all the same depots. We have a case right now that's a pretty big case with 37 different claimants. And we're dealing with how are we going to deal with the depositions? How are we going to deal with the discovery? We don't want 37 lawyers to get up there and do depositions. Let's kind of put together a lead team, and we will take and do the depositions. We will put forth the written discovery. So you have to deal with this sort of thing when you have a claim like this. And adding 10 claims is absolutely miserable for the plaintiff's attorneys.
Be alleging that the individuals in the house diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims.
So Brianna said, Peter, why do you say prosecute? So in the civil side, plaintiff's lawyers do institute or initiate and prosecute the claim, right? It's not a criminal prosecution, but it is, we are the ones as plaintiff's lawyers. And now Karen Reed's defense team is also going on the offensive. So they would be prosecuting these civil rights and civil conspiracy claims. That's why I say prosecute.
How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity. At a minimum.
It's very unusual what he's asking for. And at the end, he said, I'm happy to brief it so Mr. Diller, who's the plaintiff's attorney, has a chance to respond. Now we're going to find out he didn't give Mr. Diller a heads up. And the judge is not going to like that. That's number one. Number two, you better believe you're going to brief it and give Mr. Diller a chance to respond. The judge is not just going to say, yes, you can do this. Let's go ahead and do it that way. No way, not fair. Litigation by ambush. You have to give Mr. Diller a chance to respond to this.
Are you going to do that? I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive.
By the way, do you notice what word he did not say when talking about Proctor and Tolley and Buchanan? He did not say a 1983 action, right? He did not say that.
Out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
I'm going to skip the arguments from the two bars. Not that exciting. But we are going to listen when we get to the plaintiff's lawyer here, Mr. Diller.
This action?
Absolutely not, Your Honor.
Counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
Judge is not happy. He's like, this is the first we're hearing of this, Judge. So that's not how it should be done. I'll just tell you, not how it should be done. I'm sure people are going to disagree with me because Karen Reed's lawyers can never do any wrong. Absolutely not how this should be done. But they're building the drama. They know they have eyes on it. They know the public push helped them in the criminal case, and you can expect the same thing in the civil case. But we're going to hear from the plaintiff's lawyer that he's kind of welcoming this because he's putting the whole, circus or whatever you want to call it. He's saying, Karen Reed, that's one of the bad things that she did. The judge has mentioned the cameras. This, I believe, was done partially, at least because there are cameras, because we are watching. That's probably one of the reasons it was done this way. I don't know these defense lawyers. Jackson said they're amazing. I assume they practice in this jurisdiction. This judge probably knows them. That's how it is for us. The judge knows all of us on the plaintiff side, all of them on the defense side. So he probably knows these lawyers and knows them to be, ethical if they are assuming and things like that. So it's not going to be something that's majorly shocking to the judge, but the judge is like, that's not how we like things done. And you don't usually want to start on that note with a judge. However, everything is done for a purpose. Everything has a risk and a reward. And the defense team felt like the risk of pissing off the judge was worth the reward of everybody talking about, bang, here it is, not how we expected it to be announced. I'll just be honest. We expected it to be announced with a complaint filed where we can read all the facts of the complaint. That's not how this was announced, and that was the surprise.
We expect the courtesy of a meet and confer, or at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in federal.
So then who's the first one to say 1983? 1983 usually is in federal court. Peter, why is that important, Hannah? Because he's right. 1983 actions are usually in federal court. And we're going to take a second to discuss this. I think this might be the time, but let me see what else he has to say real quick.
Court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor.
So he's like, we don't want to deal with any of that. Okay, Judge, our justice, we want it to be done in state court. We chose state court. We have no reason to go to federal court. Michelle said, so do you think he didn't say 1983 yet because they're trying to bring it in state court first and then go to federal route if it doesn't work? I don't think that's what they're doing, but I am going to explain what I think is happening once we hear a little bit of a response from the defense here.
We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not.
So just FYI, you don't have to ask for permission to write a motion. Now, maybe in this way, but he already said they could do it piecemeal. They could answer and then they could file a motion to file this complaint here and merge these together, like he said. They don't have to ask permission to that. He's trying to do it a different way and saying, Judge, would this be cool with you if we did it this way? So Stephanie Lang, a 1983 action is a violation of your civil rights. Pretty much exactly what he's talking about, filing for or against those law enforcement officers that he mentioned. In a previous video, we broke it down in detail. Nucleus of operative fact. It's funny.
Being surprised by the argument that we're going to present to the court. You'll have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defense have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So
The judge is just completely wrong on that. I'm going to agree with some of what the judge does, but right there where the judge says this is just a wrongful death claim, later when they get into the motion to dismiss the intentional and negligent inflictions of emotional distress, I think it might all be, I don't know if they're negligent or intentional, but when they get into those claims, what is part of those claims? Karen Reed lying, Karen Reed intentionally saying stuff to her niece, Karen Reed fabricating a lie with Turtle Boy and others. You may regret adding those claims as the plaintiff, because if I'm the judge, I can see where the judge is going with a lot of his arguments being like, I don't know about all this. This all seems a little too much for what we're doing here. But when you look at those other claims and you look at the facts that are included in those other claims, it may be responsive to be like, oh yeah, judge, all of that was a lie. I'm going to prove civil conspiracy. I'm going to prove the civil rights were violated by law enforcement, by the McCabe's, by the Alberts. That's why I'm bringing this counterclaim together. To me, that's the best argument the defense has, is because of what the plaintiffs, they might want to lose the infliction of emotional distress claims. Because if the defense lose those and they stay in the case, they're fighting them. And this goes in direct response to that, Judge. And those are weak claims anyways. They're going to have to prove that Karen Reed lied and made all this up and knew that she was lying and trying to inflict emotional distress and not just acting like she was distressed. Could bringing up other civilians into this case actually help the O'Keefe since they didn't file against them their homeowner's insurance in time? No. What you have to look at in these cases and what's helping one side or the other is what is their purpose? What do they want? What is their end game? And this does not help the O'Keefe's end game. Should the judge bifurcate the claims? Seems like it. This is going to be the ultimate question in this hearing. I'll tell you kind of the multiple sides to this when we get there.
We got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but
and he's going to mention that multiple times. A lot of people watching, a lot of people interested in this case. He's going to mention that multiple times.
it's hard. There are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is
With 38 people, what's 10 more?
shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the
So when they talk about tracking order, I know a lot of people had questions about that. That's like a case management order where you've got to do all your depots by this date. You've got to have your mediation done by this date, which is when everybody comes together, tries to settle the case. You've got to have your expert depositions done by this date. We're going to have trial on this date. Back before your expert depositions, we're going to talk about how many jurors we need, how many days we need for trial, things like that. So it's just basically setting out a schedule that we make us keep the case on track.
tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027, with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here
He means in another case, not in this case. Everybody settle down.
in a little bit. But for now, so you understand it, we could get to a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this.
I'd be surprised if they were able to get the trial in spring without adding those 10 parties. The judge is 100% right that if they add these 10 parties, no shot we're going to trial in the spring of 26.
Procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative
Well,
procedure.
you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly.
So he said affirmative claims. I don't know if he also said affirmative defenses. The judge would be 100% right. These are absolutely not affirmative defenses. These are counterclaims or cross claims, I guess, because it's not even, it's bringing somebody in so that you could file a lawsuit against them, not a counterclaim suing the O'Keefes. Very different.
Separate third-party causes of action against people who are not part of this litigation, right? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense.
It's not an affirmative defense in any sense. The traditional or the modern, I guess, defense, they're not affirmative defenses. I'm trying to be creative. And I think at one point the judge says something like, despite your novel arguments, that's not usually a compliment from a judge to a lawyer.
In the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach.
And okay, so here's where I'm going to take a second now. So everybody, if you want to tune out, because I'm going to talk for a second about the 1983 case, federal versus state. So he's right in that it would streamline the process for Karen Reed. Okay. Can someone affirm? Good question. So before I get to that, define affirmative defenses. Affirmative defenses are defenses to the claims that the plaintiff has brought that the defense has to prove. Right? We always talk about different burdens of proof, but like an affirmative defense could be, a third party culprit, or like in criminal, an affirmative defense can be entrapment, right? An affirmative defense can be self-defense. It's something that the defense has to prove. They have the affirmative duty to prove the defense, as opposed to, I didn't do it. It's not me. There was no accident. That's not necessarily an affirmative defense, right? The poking the holes. Okay. So now let's talk about the federal versus the state claim for 1983. So state courts have concurrent jurisdiction, which means they also have jurisdiction over these civil rights claims, over these 1983 claims. It's usually suing state actors for violating an individual's civil rights. People are asking, can the O'Keefes join Karen Reed? No, because these are Karen Reed's civil rights that will be violated. She is the plaintiff. They did this to her, not to the O'Keefes. They may have their own claims, right? They may have their own claims against, state actors and can file those claims themselves. They cannot join Karen Reed. So usually a plaintiff would want this in federal court. You get certain boosts potentially from federal court. Sometimes they can feel like litigation in federal court and discovery in federal court can be better for them. Sometimes defendants feel like it's better for them to be in federal court. What do we know about federal court, folks? No cameras and a lot less information coming out. So that could be one reason that Karen's team doesn't want this to be in federal court. Music to my soul said, by announcing it this way, it seems like AJ and team want the public to feel like they might miss breaking news if they don't tune into these streams. So here's what I'll say. That could very well be true. But also, I kind of feel like people are already there, right? Michelle, Peter, the best defense is a good offense. Absolutely. But again, if this case is not consolidated together, does it really hurt the O'Keefes if it's in a completely separate jurisdiction? Okay, so that's step number one, is where a plaintiff chooses to file the lawsuit. That's how it can get to, it's a federal question, right? A 1983 action, that's going to be a federal case. You can absolutely file in federal court as a plaintiff. But there's another side to all of this. And a lot of times this happens in underinsured motorist coverage cases where, we file against the at-fault party, we settle with them, and our own client's insurance. You should have underinsured motorist insurance. By the way, it covers yourself if you're hit by an uninsured driver or a driver that has very little coverage and can't cover the damage done to you, like a wrongful death or serious injury. So make sure you have your own underinsured motorist coverage. But a lot of times, if we sue the underinsured motorist carrier, they will, because they know state court is usually much better for bigger judgments in these cases and bigger verdicts in these cases. So what will they do? They will remove the case to federal court. So they file a motion saying this is a federal question. This is a case in controversy of over $75,000. They'll check all the boxes and say, Judge, this is a case that should be in federal court. And they almost always win. There are exceptions, but they almost always win. And we fight it. We want to keep it in state court, but they still remove it to federal court. And if even if this judge was, thinking about considering this, if I represent any of law enforcement or any of the McCabe's or Alberts, that's the first motion I'm filing, and you have to do it timely. Filing a motion to remove the case to federal court. So whether the plaintiffs want to or not, they make them the separate defendants, not the O'Keefe's, not C.F. McCarthy's, not Waterfall, not Karen Reed, but the McCabe's, the Alberts, law enforcement, or former law enforcement. They file a motion to remove the case to federal court, saying that's where this case should be. To mix these cases together, Judge, now we're going to have 10 plus, we're going to have 10 defendants here, 3 plaintiffs here, 5 defendants there. It's going to be so confusing on who gets what discovery, who's doing the depositions. All of our arguments are going to be opposed to each other. It's going to be a mess of a jury trial. This case is better for federal court. And then the judge is going to have to make the decision, should we remove, and they're not going to look at, all parts necessarily, but they're going to look at that motion for should this 1983 action be in federal court? Would that be better? Would that be appropriate form of justice? Who is the they? I think you're asking who's going to look at that. This judge is going to look and make the decision of if this should be, yes, $75,000 in case in controversy and diversity of citizenship. But should this be in federal court? And that's, I think, the toughest hurdle for Karen Reed's team to get over. Third-party claims that should be in federal court. Now, one of the exceptions there, and I don't know off the top of my head, I'd have to look at Massachusetts, but if they only file under state claims and no federal claims, if they can find just state violation of civil rights for state bad actors, and they only file under state claims and no federal claims, so there's no federal question, it gives them a much better chance to stay in state court. So we'll have to keep an eye on what claims they actually file. Incredibly interesting arguments to me. And it's not a dead bang winner. Frankly, most of the time, Karen Reed's team would lose if the new defendants filed to remove this case to federal court. But I think if they have some novel ideas and they get creative, it is possible for them to stay here. Why do they want it to be in federal court? To keep these cases separate, to not give Karen Reed what she wants, to make her litigate these cases twice, to bleed her dry, which they all tried to do in the criminal case, right? Trying it twice, even though they knew they had a loser. Still just making her life difficult. That's part of what happens in these litigations. Is it right? No. Is it good? No. Is it moral? No. But they also just maybe feel like they've got a better chance in federal court because it's much more shielded from the public than state court. And I agree with that logic. I think that's absolutely better for Proctor, for Tolley, for Buchanan, for the McCabe's, for the Alberts, for the Higgins. I think it's much better to have this case outside the public eye. That's exactly what they want. I don't think transparency is going to be good for them if they're looking at that case. If the plaintiff claims Karen Reed was drunk and intoxicated, how can they try to claim she knowingly influenced emotional distress on the niece? Multiple theories, I guess. That's for them to decide. It's not my claim, fire medic, not my claim to prosecute. Joanne, Peter, if the judge says no to the 10 claims, does she have to go to court separately for each one of them? No. She'll be able to consolidate them into one claim. She can try to bring them in multiple ways in a state court. The judge can either say no or they can remove them to federal court. It's not like those cases are going to get dismissed. Karen Reed's worst day at this point is just having to file a separate federal lawsuit. It's not like they're all going to be booted. What's the benefit of staying in state court? So I described that a little bit. I think the public interest, obviously, the transparency, usually discovery is more broad in state court. And having these all together, I think, will save her a lot of time and money. Ashley, how can you keep all this organized if allowed? It's difficult no matter what. We're learning this right now in Civ Pro 1L Life, Legally Diamond. Yeah, I should have you explain it to the chat, Legally Diamond, how all this works. Diversity of citizenship, a federal question, subject matter jurisdiction. Daryl Brooks taught us that one. All right, back to the hearing. By the way, this is going to be a longer stream. We're going to go over an hour. Hopefully you guys are okay with that. Make sure you've already hit the like button. I'll remind you at the hour mark. Pumped everybody's here. Make sure you're subscribed. Let's get to it.
And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But you have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time. Just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay.
And I agree again for Karen Reed. But if I represent Yuri Buchanan, no, I don't want to be involved in all these depositions that maybe have nothing to do with my case, right? If I'm Brian Higgins, I don't want to have to deal with all these depositions in this case that have nothing to do with my case. So that's also what the court has to look at, not just what's better and more judicially economic for Karen Reed, but for everybody involved.
All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they
And again, that's what I'm saying. You can use that as an affirmative defense, but your third party culprit, basically affirmative defense in civil court, doesn't mean you get to sue that third party and get money from them. So Karen Reed wants that affirmative defense, but they also want to file a lawsuit and sue those third parties for money.
can't meet that burden, then it should never come into our case. If they're seeking to,
Oh, by the way, what do all these claims do for this case? What does it mean for this case for Karen Reed's team? One big D, discovery. Discovery. They are going to get so much information, potentially from Morrissey, with the McCabe's, with the Alberts, with Higgins, with Proctor, with Tully. You file these lawsuits, it could open up the floodgates with discovery. And that's something they really, really want. And we're about to hear the judge say, I'm going to decide this assuming everything the plaintiff pled was true. At some point, he's going to be saying that about Karen Reed's claim. I'm going to assume all of this is true while you guys are trying to get this case dismissed. Yeah, maybe another big D. Depots.
overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that because nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
We have also read this together. We will break down some of these arguments, but let's listen to their arguments about dismissing the infliction of emotional distress claims. The court is going to decide these, but the legal arguments we've already done. But the facts that are included in these claims, I think, can have a lot to do with what happens in the future of this case.
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts.
So before we do this, let me just answer this just to be as an overarching answer. Crystal said, how likely is it that they will be able to add these claims for all the people mentioned to this lawsuit? I would say maybe 50-50 that they'll be able to add it to the state lawsuit. And then after that, I expect those defendants, those 10 new defendants, to try and remove it to federal. And I would say 90-10 that it gets removed to federal. I shouldn't even do that probably. I should probably wait to see what claims, how creative they can get with the claims. But here's what I'll say. There's a 100% chance that in some jurisdiction, in some court, Karen Reed and her team are going to be able to bring these claims. Whether it's state court, federal court, whatever. I don't care what court. They are going to bring some very legitimate claims of these 1983 actions. And then the civil conspiracy, we'll see what they can prove. But even if they can't prove it, they're going to get a lot of discovery.
13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no, the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here for the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. And we rest on our papers. Thank you, Judge.
Thank you. So let's turn to the other defendants.
It seems like that might not be the state of the law in Massachusetts. I haven't done all the research on negligent infliction of emotional stress being at the same. I would think that you could file both, especially in certain circumstances, which they're going to cite a case of somebody who was actually in the car at the same time as the accident happening, which is very different than a lot of the circumstances here.
If they want to be heard, you file separate motions, essentially arguing the same relief. But if you have anything you want to add, you certainly can. Waterfall.
And I'm going to skip Waterfall and CF McCarthy's, who just kind of piggyback that argument.
23, it's a 1982 case. So it would seem that we're talking about
So the judge does respond with a case of his own that he found.
wrongful death, emotional distress injuries. If you've reviewed that case, I'll give this case site 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but
That's the point, is it's not a complete bar, but it definitely bars certain claims. And that's what the judge has to consider, because they do make some really good arguments. They make some good arguments. I wouldn't be surprised if this one went either way, but I think regardless of what happens, the defense is going to be able to use what happens here.
my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell.
Yeah, and I agree with that argument, and that's why I said regardless of if they're dismissed now or not, I really don't think these have any merit whatsoever. So I'll just tell you how it goes in civil cases. You assume you're going to lose these motions to dismiss, but on claims like this, you're really not worried. I don't want to say you don't care, because these do open up a lot more discovery. If they could get rid of the emotional distress claims, it would make that case simpler for Karen Reed and her defense team. But even if it's there, doesn't scare me if I'm them.
Sons, a case that goes back to 1980 also kind of speaks to that issue too. Let's hear from CF McCarthy's on that. Anything else to add on the what will happen in just a few moments? I'm going to go closely. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that.
So multiple times he did this. I want everybody sitting here to understand. He's explaining things to the cameras, the crowd. Why do you think he's doing this? Judges don't often feel the need to make sure everybody sitting in the courtroom knows exactly what we're doing. Just so you know, I have to take all this as true at this point. I'll leave that to you guys to discuss. Why do you think he's doing so much of this? Why is he explaining it to people that are not parties, to people that this litigation does not affect? Sure, I know there are some family members and things and potential defendants sitting in the gallery. Why do you think he's doing that?
The comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
Thank you, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor.
And if the motion to dismiss is ever filed against you, you want to remind the court, everything we say is true. Everything we say is true at this point. Judge will deny, allow to be decided on a motion for summary judgment. So this is more common as to what happens. I do think they make some good arguments here. And if you can cut out some unnecessary litigation, I would always try to do that as a judge, but I'll never be a judge. People are saying, I like this judge. I don't like this judge. I like him so far. I like judges that explain things. I like judges that explain things because if I disagree with their explanation as a lawyer, I'll say, Judge, hold on. I disagree with this, which I said something earlier that I would disagree with the judge on, that this is just a wrongful death claim. Because we have these emotional distress claims as well, which open up additional discovery and responses. Like, we got to prove it's true what Karen Reed said to everybody, because this is part of their claims. We'll hear it.
Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard. The Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright-line test for such cases. Number three, Your Honor, the defendants fail to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer.
Question, what is NEID? Negligent infliction of emotional distress. Sometimes I say IED, EID, whatever it is, all the acronyms, but you understand. So yeah, also, if you're Tully Proctor, Buchanan, Albert McCabe, Higgins, not a good day for you. Not a good day for you, because a civil lawsuit, civil discovery, when that stuff starts coming out, was there any criminal action? Are they going to get any evidence of criminal action? Are they going to share that with anybody, with these people individually, right? Regardless of investigating the investigation and the federal investigation and all that stuff, put all that aside. But are they going to find any personal criminal acts of any of these people in discovery? Should they be worried about that?
And his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from.
Like, again, another thing, I told you there are going to be multiple things done by the cameras or for the cameras. This was something I felt like was for the cameras. You did not need to give this much of a factual background, I didn't think, but it is what it is.
Each other, leaving 2 young children orphaned. JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something.
Everybody's saying that's not what happened. He's lying. He's wrong. We just listen at this point. The judge is just listening. This is not the time to argue. Discovery will bear out the facts. The jury one day will determine what the facts are. At this point, all of these facts are assumed to be true for the judge to make the decision the judge needs to make, which the judge has explained and will explain more. And again, I know everybody's going to get mad in the chat, and I understand that. Legally speaking, we're understanding how the legal process works. At a motion to dismiss part of the phase of this case, this is exactly how it's supposed to be done. There's nothing wrong with this outside of, obviously, this is a longer explanation than that's needed, but we sit here, we listen.
Something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public.
A campaign of misinformation involves a blogger named Turtle Boy. To me, this opens the door and makes the Alberts, the McCabe's, and law enforcement and former law enforcement relevant to this case, inextricably intertwined. We are going to have to do this discovery, Judge. We are going to have to depose all these people. Why not make them parties and just knock it all out at once? If they didn't have these claims, it might not be so. But these factual claims and arguments he's making, to me, completely bring all this together. That's what may make this in the small percentage that doesn't get removed to federal court, because the vast majority of these 1983 actions, if one party wants them to be in federal court, usually they are. Lou Lane said, do you think the McAlberts will push the O'Keefes to drop the case? It ain't going to help them. I think the O'Keefes could drop the case today, and Karen Reed's team's still going to go forward against those 10 defendants. That'd be my guess.
Information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are...
When they say overlapping with the wrongful death statute, it can't just be they're sad because their loved one died, right? You're sad because your loved one died and you no longer have a relationship with them. There are already damages in the wrongful death statute for that. So you wouldn't need to file another claim on top like IIED or NEID, right? The emotional distress claims. You wouldn't need to file that because they're already encompassed in the wrongful death. But if something else happened, then you can have this separate cause of action, which is, Karen Reed going lying, intentionally hurting Kaylee. That's what they're claiming, right? And at this point, we're taking those facts as true. Or the O'Keefes seeing John at the hospital as a separate act, not just that he has passed, but they had to witness it. Those are the additional claims and facts they're adding on top to get to the emotional distress claims, in addition to the wrongful death claims.
Excluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law.
We're quibbling about something here and maybe conflating some issues where the wrongful death statute absolutely does encompass some emotional distress damages. But there are scenarios where you can have a separate claim. Is this one of those scenarios? That's what the judge has to determine. So, like, again, we've already said how if I'm holding the hand of my son while he gets hit by a car and I see it all happen, I have my own emotional distress because I'm there in the zone of danger. I could have been hit, and I get the emotional distress for now losing my son forever, or vice versa if he lost me. So you can see how it doesn't encompass all emotional distress claims, but it does encompass some.
Pointed out the Cimino case, where, let me just point out first, the wrongful death statute, it has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent.
I believe that's the one where the father was actually in the car with the son, so very different.
Infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress as the concept has evolved in the Commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here.
By the way, whenever the judge cites a case that's good for you, it's a good idea to mention it multiple times. I'd do the same thing.
In this court, and I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital. so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone, does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared.
I'm laughing because I see you guys putting objections in the chat. Objection relevance, objection long.
Dead. The purpose of the law is to distinguish
This moment where he can say all this stuff. Nobody can argue with it. There's no point in arguing with the facts because if you argue with the facts, you've already lost. If you're a lawyer arguing for a motion to dismiss and you start arguing with the facts with the other side, you've already lost because those facts are going to be taken as true.
between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death.
People are saying, am I dumb? He's speaking about facts that were already disproven. They have not been disproven in this jurisdiction, in this court, in the civil court. So he's allowed to say them as true at this point.
Of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer.
So I'm especially interested in what you think about the niece's claim. So I broke down the entirety when we read the motion at length and dug into this. Generally speaking, I think this, like that she experienced it, I totally disagree, even if we take the facts as true. But if they go with kind of a Gabby Petito situation that Karen Reed said this stuff to her intentionally, lying, knowing it wasn't true, just to hurt Kaylee, just to cause her emotional distress, then maybe they can go forward on a IIED claim or any ID claim. Again, I think it's a real loser when you get to try it and after all the discovery. But to get past the motion to dismiss, if that's your only goal, I think there may be some arguments there.
You also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should.
Here's a question, right? Just thinking about this again, not how we think about it at this point, but extreme or outrageous, or how someone would be acting like maybe a doctor would opine that she was acting exactly how somebody would in a state of shock and distress. We already know there's going to be expert testimony to that fact. But that's not how we argue at a motion to dismiss phase. Wouldn't that make any defendant who puts on a defense liable for emotional distress? Nah, not really. Being sued for rallying her followers or just having supporters, is that illegal now? If you are lying and you know you're lying and you're doing it on purpose to make people miserable and to make them emotionally distressed, then maybe. Do you think that's what they're going to be able to prove here? That's the question. Brown-eyed girl, this is a good question. Why is he saying discovery is late when he started talking? Don't they have until next year? I love smelling candles. Anybody else? This is a good question. And yes, discovery closes next year, but there are still time limitations on discovery. Certain discovery, you send it out, it has to be responded to in 30 days. But the last point at which you can ask for discovery, do depositions, which are part of discovery, ask for requests of documents to be produced, all of that ends at a certain date. But it doesn't mean every time somebody asks you for discovery, it is time limited. So it is still due in 30, 45 days, depending on what it is that you ask and what the rules are in that jurisdiction. He has to know he won't win. Why take the case, time, money, down the drain, publicity? Maybe he thinks he's going to get a settlement from the car insurance company. I don't know. I wouldn't take it. This is not my claim. This is not something I'd want to prosecute on the civil side. Not interested in the least after hearing what the experts and the witnesses had to say on not one, but two trials.
Should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenk, 1979 case we cited to, Your Honor.
By the way, we are past the hour mark. We're almost done with his part of the argument, and we're going to hear from the defense again. So take a second, take a deep breath, hit the like button, subscribe if you have not subscribed. Make sure you are subscribed if you think you are, because again, like I said, people are telling me they're getting unsubscribed. So check that out. And now back to the end of his argument. Then we get to hear from defense again, and we get to hear from the judge again. There's still more I want to talk about for sure.
Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we posed to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice.
John said, what civil is your game? I assume you mean to taking this case, but I like to win, John. I like to win, and we always win on the civil side. I can't guarantee that we win a case, but the civil side, you get to choose your cases. You should win. Just like prosecutors. Only pick cases you feel like you know you can win. And you're not going to always be right? You might lose, you might win, and it's not as big of a win as you thought it would be, but like you get to choose the cases you have, and you should win those cases. Josh said, I want to see how this guy proves that JJ was hit by KR's SUV when the ME and ARCA can show he wasn't hit. The CW tried to prove that twice and failed. Yeah, I'm interested to see that as well. I'm also interested to see how Karen Reed is going to prove civil conspiracy, right? I think they're going to need a lot more discovery or a lot more evidence than we've seen so far, and I think it might exist. We'll see how it comes out. Arizona, if the niece is 18 at the time of the hearing, will we be allowed to watch her testimony? Theoretically, yes, because she is an adult. But if they think that she still needs to be protected and for her own safety and there are extenuating circumstances, potentially I've seen cases where even 18-year-olds, they have not allowed cameras to view them. But I think the defense would have a right to fight that. Would they? I don't know. But it could change when she turns 18, not guaranteed to.
To speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law.
Rude and clumsy versus extreme and outrageous is not the comparison I would make if I was the defense. I would say extreme and outrageous, or exactly what you'd expect somebody who is in shock and dealing with distress themselves to act, right? Not rude.
As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extremely outrageous? Again, those are questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired, and they are now fair game. Discovery will track how much leaked information defendants should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polite case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control.
I think I mentioned this in Alan Jackson's interview when I did the reaction last week, that by the way, it was recorded on Friday. There was all sorts of things. People were like, "Oh, how do you not know this or I not know that?" And the order came out with cameras that are going to be in here, and it's like, people love to do that. People love to do that to me, which is fine. It's fine. I love all you guys in the comments. But you knew they were going to try to use that against them. What he means is exercising her First Amendment right, which she is allowed to do. She's allowed to waive her Fifth Amendment right. It's her Fifth Amendment right. If she wants to waive it, she can. Nobody can force her to. But now they can force her to sit down and be deposed, which you can expect is going to happen. Cleanse and fire, leak public information. How does that make sense? Yeah, I think he probably means leak information to the public, but words are important. Definitions are important. Don't have to come to a trial because more emotional distress. I get what you're saying. But there are legal causes of action that put certain things in order to make you able to sue for them, and certain things not. Like you can't sue for being sued.
She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more.
By the way, to me, this is opening it up and saying, this is why we need to handle all these claims here, Judge. Listen to these factual allegations and accusations he's making. This is all the same. We need to do this here and now in this courtroom, in this courthouse, in this case.
This is an exceptional case that requires exceptional discovery, that requires...
That's not, you don't want to make that argument, because then we make an exception and we bring all 10 of these defendants and we keep it right here.
Us to decide this matter by a jury, not...
If it was me, I'd be like, Judge, this is a wrongful death case, just like any other wrongful death case. We believe Karen Reed hit John O'Keefe with her car and killed him. That is a wrongful death, car accident, car versus pedestrian case. This is simple. We don't need to muck it up. We don't need to make it difficult, etc.
My motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute.
So again, that argument doesn't matter here. But we've got cameras. We've got people watching. So he says, listen, we are going to refute those allegations. And I think it's smart to do at this point, but that's not going to have any legal pull with this judge.
Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit, part of the car accident, gets up, runs to see his son. It's contemporaneous.
I have a very similar, very sad case like this where it was witnessed by another party, and we are filing the same exact claim. Additionally, because they were involved and there and saw it and ran to render aid to their injured loved one. That's important. That's a big distinction.
It's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have
He's going to give another explanation to the crowd.
sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful, and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected.
So he says, I got to take them all as true in every reasonable inference. Ginger, can Karen assert her right to remain silent due to the Commonwealth keeping her phone and investigating her for witness intimidation now since it's ongoing criminal case? She can maintain her Fifth Amendment privilege potentially on witness intimidation centric questions, but not just generally about what happened that night and things she's already been tried for and acquitted. So there could be some nuance there. KK, question, are civil judges allowed to know about criminal case and facts? Yes, this civil judge will know. One of the things that they're asking for is the complete file from the DA. God knows how complete it actually is. But they are seeking that as well in discovery, and something they have not fully been given.
The lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does, and so as a result, there's appellate processes. And so what I envision for the
This is literally what mediators do at mediation. It's almost like they try to, I'm not saying he's doing anything inappropriate. I think it's completely appropriate, but you want to make sure everybody knows this is not easy. You might not win. It might not go like you think it's going to go. Maybe you should consider settling. If you don't settle and if you go win at trial, guess what comes next? An appeal. Karen Reed, you may have won your criminal trial and they can't appeal that. But if you win this, they can appeal, and it can last years and years and years and years. So maybe just settle for a nominal amount or what you think is nominal. You know, a lot of times we settle cases and neither side is really excited about it. This is literally what mediators do to try and push ADR, alternative dispute resolution. Very interesting timing from the judge to do this early on in a case.
Parties, unfortunately, in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case. I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. I mean, literally, I've talked to the clerk. We could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what
I'm not sure that's the number one thing anybody's thinking about.
you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous.
I have a case that was a big case we won in 2023. We're still in post, and we even won the appeal, but now there's a bad faith case going on. He's absolutely right. He's absolutely right. And Future said, don't civil courts usually push out of court settlement? They're not wrong. And that in most cases, it could be the best case scenario. You don't have to waste any more time. You put it behind you. You've got the money you need to pay medical bills and your pain and suffering and all of that. So a lot of times it is the best option, but not every time. Right? Not every time. The vast majority of civil cases that go like this, one side agrees, I did it, I'm at fault, I caused this damage. We just don't agree on how much the damage costs, what is the money, and that's why a lot more of them end up settling, because it could be a big risk, right? Jury gives us a huge number, or jury gives us a little number, and you got to think that through. What's the jury going to think? KK, question, if they go federal, are cameras still banned in civil and federal court? Yes. Yes. And I don't know how it's going to be there, but in a lot of civil cases that I've tried in federal court, the jury selection process is nowhere near as good as state court. State court, you can do so much more in jury selection, actually talk and get to know the jurors. Federal court, it was not that way at all for us. And it makes a big difference. I much prefer civil state court. Criminal, depending on the case, I might prefer federal court. But mostly state court as well there, because the feds are so much better at it, at prosecuting cases.
Pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try.
By the way, the 2023 trial I had, I think was a 2018 or 2019 case. So the accident happened in 18 or 19. Trial didn't happen until 23. We're still fighting about it after a jury's already said, you won, here's the amount of money that we agree with, that the plaintiffs agree with, we're still there.
To put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case, realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore it. We say this when people lose loved ones, or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a...
Right about that too. If you're doing it out of principle, or you want your pound of flesh or an eye for an eye, that ain't what the civil courts are for. It's about money, whether you like it or not. That's what it's about.
There's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that, and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have two ongoing, as far as I understand, the two businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss.
All right. So that is the end of the hearing. I got a couple questions I want to answer because they're good ones. Arizona said, when there are multiple defendants, can one or more settle without the others? Absolutely. Any case that is an individual claim, one can settle, like CF McCarthy's could settle tomorrow and they're done. It's behind them. They don't have to pay lawyers anymore, whether they think they did anything wrong or not. Let's say it's 10 grand. They're like, we're going to have to pay our lawyers 100 grand and all these experts forget it, take 10 grand and move on. So yes, that can happen. Not. Can the insurance company settle without Karen's agreement? Usually the answer to that is yes. That they say, hey, this is our money. We have this policy. We're the ones that have to spend all this money on defense attorneys. So we're going to settle. Now, if Karen has to sign something that's an admission of liability and she refuses to sign it, potentially they could do that. Then you could potentially lose your insurance benefits or lose their right to defend. There's all sorts of things that can happen in the background. But yes, generally, insurance companies hold the purse strings. And I have seen them make decisions that maybe the defendants don't necessarily agree with, but it's behind them and they don't have to deal with it anymore. So we'll see if something like that pops up. Megan, hey, Peter, this is off topic, but my cousin, Corey Conroy, your old teacher, says hi and congrats on all your success. God bless. Corey Conroy. When I was like in 6th grade, he was my church camp counselor. It was the absolute best. We all thought he was so cool. He could like rap and play basketball and dunk and stuff. We all thought he was so cool. And the coolest thing also, and when I was in 6th grade, how long ago was that? I don't know, 25 years. That dude looks exactly the same. I just saw him last week at church. Looks exactly the same as he did when I was in 6th grade. So what up, Mr. C? That's awesome. That's hilarious. What a small world. All right, hour and a half. This was a bit of a long one. Thank you guys for hanging and sticking here with me. Hopefully you've already hit the like button. If you haven't, hit it now. Make sure you're subscribed. We're going to be covering this case. I'm excited to cover this civil case. Thank you guys for sending it all to me and sending me your questions. Keep me posted on what's happening next in it. I'm sure we're going to be talking soon about it. But until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.